Did you take the place in the homes of Papa, who great children? Muslim trust. Those Thinks only one thing, and then it's all fiction. Space is disgusting. You don't want my help. I couldn't jeopardize my grandmaster's any time in this trust. You could join me at the site to have some time and actually call the grandmaster and I'm seriously thinking about that. Oh, sister, it's for grass. It's a strong chance. But now I'm saying, say something.
Greetings, 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 greetings. It is I, King Clifford Jefferson, Senator Godfrey, the fifth counterban Jew, the son of folk, the ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know here at the Third Temple English Church of England as Jesus Christ, or the Vicar of Christ, or Melchizedek, which means the King of Righteousness. It is November 13th, 2024, which would be equivalent to the Berber year 2974. I greet you in the name of my Queen Sister Godwinson from the House of Godwinson, which we'll be discussing today, as well as my Archbishop Belmont from the House of Belmont, as well as all officers on staff, members here at the Third Temple English Church of England, as well as our predecessors, our successors, our ancestors, our martyrs, and our saints. Okay? Today, this lecture is going to be a beautiful lecture, which is called Breaking Their Color of Law is a Necessity for the English People Here in America. Breaking their color of law is a necessity in English criminal law for the English people here in America. Okay? So once again, I'll open an invitation for all those who will be joining me this evening in this beautiful lecture, as well as if there's anybody who would like to sit in dialogue or break bread here at the Third Temple English Church of England, you're welcome to send an invite or invitation to us at the Third Temple English Church of England, or we can invite you here at the Third Temple English Church of England to our platform, okay, to discuss this matter like men. All right. Once again, all donations are welcome in lieu of free and common soakage. You can send them to the Third Temple English Church of England or $ Clifford Jefferson L. Okay. So with that, let's get started with this marvelous lecture. Give me 1 second, bro. Once again, you're never going to hear this lesson or a lesson like this from any other platform that you can find out there on YouTube, TikTok, Instagram, or whatever there's that one are able to search for enlightenment. Okay. Once again, when we teach here at the Third Timothy English Church of England, we bring evidentiary facts, genuine material facts that no one can dispute. All right. We just don't teach this here at the temple, but we also implement that in our political society as a part of our protection of our what we call civil rights under English common law. All right. We now have two present cases filed within the Superior Court of New Jersey in 2024, a civil and criminal complaint. Our criminal complaint was filed against Aya King Clifford Jefferson, in lieu of a claim that I actually violated their color of law. And we know what color law means. But the reason why I violated their color of law, which was because it was a necessity, okay, to violate their color of law. All right. And the necessity to violate their color of law was justified based upon the color of law in which they stated or claimed I broke. Okay. I'm going to show you right there in the statute, in their own statute. Remember, they say anything you say in a court of law can be used against you in that court of law. Okay? Very important. Pretty sure majority of you who have been watching our lectures here at the Third Timothy English Church of England are pretty much familiar with the preliminaries of this civil and criminal case that involves us as a civic and political society. Okay? So this is pretty much my arguments that I'm going to raise at the civil hearing in lieu of the defendant's, i.e. the state's motion to dismiss for claiming that I failed to state a claim which relief can be granted. And this is all based upon New Jersey revised statute annotated Title 59, which they claim to have some type of immunity under in regards to if injury occurred as a result of them acting in their official capacity. Okay? They claim they have immunity. Okay? So that means pretty much saying that the laws that the citizens or their citizens or what they identify as citizens go by, they pretty much have immunity against any type of retaliation brought forth by way of some type of litigation in the court of law. Okay? Very important that you understand what it is that I'm talking to you. All right? Very important. Once again, this is not to go against any platform that's out there that's actually trying to liberate a people. The United States congressional election based upon the presidency does not involve the affairs of the Englishman or the English woman, all right, of the English nation. They involve citizens of the United States, and that was based upon the Naturalization Act of 1790, which is their continuity of government. Okay, every law that's enacted by a president or oncoming president is based upon an enactment of a bill or a joint house resolution. Okay, all right, it's not based upon any legislative enactment or constitutional declaration in regards to the affirmative action that should be taken. That is the, as I say, precedence for any type of litigation or any type of counter for any type of event in regards to a necessity. Okay? A necessity. So without further ado, let's get started. This is the preliminary brief argument that I'm going to use in lieu of the formal brief that was submitted to the Superior Court on behalf of the civil complaint that I filed, and it was opposed by the State Attorney General by way of a motion to dismiss for claims that I felt a stated claim, which can be prosecuted before a court of law, in which my opposition painted a different picture. Okay, you don't have an immunity based upon some type of statute that which created your immunity, if the statute that you created for your immunity was created in fraud, okay, or what we call malice or wishful intent. All right, very important that we comprehend that. All right, so I'm just going to go through the first couple of excerpts of my brief argument so that you can get an idea how important this lesson is in regards to understanding that in order, we must break the color of law. All right, we must break that color of law, which is a necessity. It's needed, okay? It's needed for us as the Anglo-Saxon Berbers or the English heirs to be able to come back under the fold and protection of our law, okay? It's called the choice of evils. You ever heard that saying? The lesser of two evils, okay? All right, so it's whether we break their law, which is the greater evil, all right, by implementing our law, which is the lesser evil, okay? Because if we didn't violate their law, i.e. color law, that means that we would be subject to their laws that we would be even more danger subject to, as has been proven from the past, especially when you are dealing with what we call New Jersey. Okay, so let's just deal with this. This matter have come before the court by I, your king, Clifford Jefferson. And the court having, after reading and considered the papers submitted with respect thereto, and papers filed in opposition to thereto, and other good cause having been shown for the entry of within the order pursuant to New Jersey by statute 47:1A-1. And this particular statute deals with the public record that the citizens have the right to examine. Okay? The citizens have the right to examine because the citizen must be known for the public record. Okay? Not any private record, not any court of record, not any municipal record, but on the public record. Okay? According to 47:1A-1, greetings, brother Marquise. Glad you were able to join us. According to the public record under 47:1A-1, a New Jersey revised statute, it states in regards to the public record, okay, that all governments shall be subject to the public access unless, pardon yourself, let me just start over. The public record is governed under New Jersey by statute 47:1A-1. Everybody's state is different. The legislature finds and declares it to be a public policy of the state that government records should be readily accessible for inspection, copying, or examination by a citizen of the state, with certain exceptions for the protection of the public interest. When you say the public interest, we're talking about the government that's governed by the public, i.e. the people, because the people are the citizens, supposedly be. and any limitation on the right of access according to the public law of 1963 in lieu of New Jersey Revised Statute 47:1A-1, as amended and supplemented, and should be construed in favor of the public right to the citizens' right to access. Okay? A citizen's right to access. All government records should be subject to public access unless exempted from that same statute, 47:1A-1, all right, as amended and supplemented, and any other statute thereto. All right. Resolutions of either of the both or House of the Legislature, regulation promulgated under the authority of any statute or executive order of the governor, and the federal level will be your president, executive order of the governor, or any rules of the court, because we know the governor governs the judiciary, all right, because he's they appoint the judiciary on the state and federal level. And any federal regulation or federal order, a public agency has the utmost, I repeat, the utmost responsibility and obligation to safeguard from the public access a citizen's personal information, which it has been entrusted with disclosure thereof will violate the citizens' reasonable expectation of privacy. Nothing contained on the public record pursuant to 47:1A-1, as amended and supplemented, should be construed as affecting in any way the common law right of access to any record, including but not limited to criminal investigatory records of the law enforcement agencies. That means that we have the right to examine the public record, okay? Not just the public record, but the criminal record of the courts of records, okay? Why is this important? It's based upon the law of necessity, the law of need, what needs to be done. What actually needs to be done in order for us as the Anglo-Saxon Berbers, as the English people, to break the color of law that has been keeping us in slavery. Okay? We will break the color of law, not through marching, not through picketing, not through voting, but understanding the law that's put us in this condition that's referenced in the book. Okay? The book governing the law. Okay? Or what we call the book of law. Here in North America, which is nothing more than what we call the common law in North America, based upon the common law understanding of necessity, especially in criminal cases, okay? In criminal matters, all right? A justification for breaking their color of law, all right? The necessity is the breaking of the law, which is justifiable based upon why you're doing it, all right? The reason why you broke their law, i.e. color of law, is because the lesser harm, i.e. the breaking of their law, will be exponential to the law that's been in place now, that's even more dangerous to us as the record has shown, okay? Because nothing that the citizens have that the public was bound to protect under the public record, under New Jersey Revised Statute or any revised statute of any state of the United States, within this case 47:1A-1, no citizen can go examine the public record, because the only thing you have on the public record is based upon your ability to go examine the public record, which is based upon that standard ID, which they use as proof of one's citizenship to enter a governmental building, which on the face of it says is not for identification purposes. Okay, for as a result of that, those laws that govern that instrument is nothing more than what we call color of law, which needs to be broken. It is a necessity, because those laws are not rooted in the common law. Okay, they're not rooted in the common law. Okay, and we say all the laws, according to Smith versus Alabama, was adopted by all the states in the Union and must be read in light of the history of the English common law, and the English common law concerns the people who created that law, okay, which would be known as the Anglo-Saxon Berbers, okay? The state of New Jersey in a case called the State versus Tate, uh, Supreme was in the Supreme Court of New Jersey, August September 23rd in 1985. Okay, decided February 24th, 1986. It says this court of common law, gap filling authority with regards to criminal law should be exercised only when there is a fact of gap to be filled. A gap to be filled, what? According to the common law. If there's no common law being practiced here in the presently, that means that there should be a gap filled because the gap needs to be filled based upon the presidents governing common law, as not the president based upon what they consider to be common law. Because the common law of England is different from the common law of what we call the states. All right. The common defense of necessity. Okay. The common law defense of necessity is often referred to as the choice of evils defense. Do everyone understand that? Let me blow that up for you. The common law necessity. Remember, this lecture is about in order breaking the color of law is a necessity for the English people here in America. Okay? But the only way you can break that is based upon your comprehension of the common law of England. Okay? It's a necessity that you understand the common law of England. Supreme Court has said that you must understand the common law of England. Because if you don't understand the common law of England and you're following laws that are not the common law of England, then the choices of evil that you have been subject to is more evil than the choice that you have to make when you break their laws to go back to the common law. Okay? We must understand. Contact that would otherwise be criminal is justified if the evil avoided is greater than that sought to be avoided by the law defining the offenses committed, or conversely, if the contract promotes some value higher than the value of the compliance with that law. Okay, so if our obligation based upon the public record says that compliance to that public record has a higher value than compliance with the law, that's in violation of the public record. Why? Because it has nothing to do with the public record. Okay, this is why the law of necessity is needed to justify what it is that you're doing and to qualify what it is that they're doing based upon it being a violation of law. Okay? The laws that they got is following are a violation of law. In order to justify that is a violation of law, you must break that law. And that law is called color of law. Okay? All that is governed under based upon what we just read in the Supreme Court case under New Jersey Revised Statute Annotated 2C:3-3 and 2C:3-2. These are the affirmative defenses that I'm using in both cases, the civil and criminal. All right? Because the reason why you filed a criminal complaint is because I broke your law. But it was needed to be broken. It was a necessity to be broken. And it was justifiable to be broken. Why? Because some values higher than those laws needed to be replaced. We are established. Okay. And what law was that? We can all agree that is the common law of England. So breaking your statute or breaking your criminal codes is the lesser evil than just going by those criminal codes, which is the greater evil that has been we've been suffering from time immemorial. Okay. United States versus Lee. What I thought. United States Supreme Court, United States versus Lee. We just read what they said about the law of necessity and the Supreme Court of New Jersey. Okay, this is in 1980. What was it? 1986. Okay, and they clearly states that you have a choice of evils. You either choose their law or you choose the common law. And contact would otherwise be considered criminal is justified if the evil avoiding is greater than that sought to be avoided by the law defining the offense committed, or conversely, and if the contact promotes some value higher than the value of compliance with the law. This is in their New Jersey Revised Statute, Criminal Code 2C:3-3 and 2C:3-2. Okay, very important. That's what the New Jersey Supreme Court stated about the law of necessity. Let's see what the United States Supreme Court say about the law of necessity. In all cases where title to property came into controversy between the crown and a subject, whether held in right of the person who was the king or as a representative of the nation, the petition of right presented a judicial remedy. A remedy was this court on full examination in a case which required it held to be practical and efficient. So that means that it was needed. There has been, therefore, no necessity for suing the officers or servants of the king who held possessions of such property when the issue could be made with the king himself as a defendant, which is the case, because based upon necessity, it means to break a law for something as a result of some unprecedented or some overwhelming circumstances, as a result of some what we call injury, all right, that will be more harmful if you had not committed the criminal act in the first place. Okay, so it's very important we understand the law of necessity as a result of we're not being under the common law of England. Under the common law of England, there's no need to invoke the law of necessity for justifiability for you breaking the law, because under the law of England, which is the common law of England, you have representatives on your behalf. Okay, very important. Why? Because the United States qualified this in the United States versus Lee, 1882 case. In all cases where title to property came into controversies between the crown, this is what it's all about. The property that belongs to the crown, because the heirs, okay, the heirs who at one time were heirs, natural people, became what we call chattel property as a result of them being enslaved, okay? And you became chattel property on the land, okay, by those who trespassed on the land. And then when they trespassed on the land, they took and laid waste to not just the land, but the chattel as well, okay? Based upon what we call the law of conversion. This is why the law of necessity is required, all right, under what we call the laws of tort, which is what we call an affirmative defense. And the first affirmative defense and the law of necessity, especially in regards to some type of property that belongs to not just the heirs and successors, but future heirs and successors, somebody has to step up and fill that gap or that void in that common law. Somebody. Who else has done that? Okay? Who else has done that? No one. All right? No one can do it. Why? Because you have to be a king. Once the king is there, there's no need for the law of necessity, because the law that you actually are operating on, which allows for justifiability, was the law of necessity. Okay? So I had to use a law of necessity to break the color of law that was created by them for us heirs here in North America to go back to the law that was here prior to they broke it, which was called the common law of England. Why? Because the law was created by the kings of England. All right? It says in all cases where a title to property, which in this case will be movable and non-movable property, real and intangible, tangible and non-tangible, came into controversy, meaning a matter before a court between the crown and a subject. The crown gives the property to the subject as an heir because it's entailed. And that property can either be personal or real property, i.e., land, building, fixtures, etc. Okay? So whether held in the right of the person who was the king, i.e. it being Lolio, or a representative of the nation, i.e. it being somebody acting in a official capacity as members of the council. All right? As members of the council. Or as a representative of the nation, the petitioner right presented a judicial remedy, which means what we call an feudal remedy. Okay? A feudal remedy. A remedy which this court, on full examination in the case which required it, held to be practical and efficient. There has been therefore no necessity for showing the officer or a servant of the king's who held possession of such property when the issue could be made with the king himself as a defendant. I am a defendant in the criminal case filed against the king in the criminal case filed in the Superior Court. Okay? I'm also the party in the civil case filed as a result of the criminal complaint filed against me in regards to the laws of necessity. Okay? I had to break your law in order to restore my law. Okay? And as a result of that, I've now filed a civil complaint, which is a necessity under the law, which allows me to do what I do based upon the public record. All right? We must understand that. Now, why is this important for the king to be there in lieu of the law of necessity, which is the state of affairs you're in right now? Why? It says point 2. Let's read it. This is 1886, United States Supreme Court. Another reason of much greater weight is found in the vast differences in the essential characters of the two governments as regards the source and depositories of power. This means their courts. Okay? The law that they put in those depositories is called the laws of precedence, i.e. their case law. All right? Those are not the depository requisites for the common law, okay? Because they are part of a different government, which has a different character based upon the English common law. All right? And it's very important to understand that because it goes on to say that notwithstanding the progress which has been made since the days of the Stuarts in stripping the crown of its powers and prerogative, it remains true today. You hear me? That it remains true today. Where am I at? That the monarch is looked upon with too much reverence to be subject to the demands of the law as an ordinary person are. And the kings of a nation would be shocked at the spectacle of their queens being turned out of her pleasure's garden by a writ of ejectment against the garden. Okay, so that means that we've been ejected out of our own land, and as a result of them coming in, taking over our land, and giving us new laws by way of what conversion. Okay, the law of conversion. All right, we must understand. The crown remains the fountain of honor and the surrounding which gives dignity and majesty to its possessors, and are cherished and enforced all the more strictly because of the loss of real power in the government. It is not to be expected, therefore, that the court will permit their process to disturb the possession of the crown by acting on its officers or agents. You hear that? Do you hear that? So we must understand what United States versus Lee is saying, as well as the state versus state versus state. State versus state, United States versus Lee. All right. So with that, let's move further on in this lesson. The law of necessity. You all need to write that down. The law of necessity. All right. In English common law, necessity in criminal law, under the statute, in New Jersey Revised Statute 2023, it said in English law, the defense of necessity recognizes that there may be situations of such overwhelming urgency that a person must be allowed to respond by breaking the law. In tort common law, the defense of necessity gives the state or the individual a privilege to take or use the property of another. So I'm obligated based upon the law of necessity because the state has taken the property that belongs to the individual known as the king or one who represents the crown. Okay? And the state has created laws that are in violation of the laws that the king usually go by, which is called the common law of England. So in order for us to restore the common law of England, we must break their color of law by breaking those statutes, okay, in which they charged me with. All right. Very important that y'all understand that. All right. A defendant typically invokes a defense of necessity only against the intentional tort. That means an intentional tort, that means that somebody meant to do something. Okay? They meant to commit an intentional tort such as that of trespass on chattel, the trespass on land, and then the conversion of that land and chattel for their own private and commercial purposes. Okay? This is what you are subject to now. So there is a necessity for someone to take the courage and have courage to break their law, to enforce the law that they had, that they were able to use to justify the breaking of their law, i.e., the color of law. All right? We must comprehend this language. Okay? We must understand this language. All right. So all this, it involves what we call the law of necessity. Okay. The law of necessity. Let's read it in the statutes first, just to qualify it. Everybody and their mama better watch this one. 2023 New Jersey Code on Criminal Justice, Section 2C:3-2, necessity and other justification in general. So New Jersey statute governing criminal offenses has an exemption for violating the law governed under the criminal code if it's based upon the law of necessity. Okay? All right? If it's based upon the law of necessity, then it's justified. Okay? Based upon the public record, it says, I'm the King of England. Okay? Which you were obligated based upon the expectancy of privacy rights that you were entrusted with to protect that right. But did you? No. So I had, the only thing I could do was use the law of necessity, which was the ability to be able to break your law because of the overwhelming circumstances of the law that we're being subject to, which is criminal in nature from the door. Okay? From the door, and when I say the door, I'm talking about the door that they open up. Prior to they open up the door that we had belongs to us, that door was closed. So there's a gap, okay, that needs to be filled in regards to how that door opened and closed, okay? How that door opened and closed. We must understand what's going on, all right? Necessity or other justification in general. A, necessity. Contact which would otherwise be an offense is justifiable by reason of necessity to the extent permitted by law. And that's whether neither the code nor the statutory law defining the offense provides an exception. Okay? That's one reason. B, other justification in general. Contact which would otherwise be an offense is justifiable by reason of any defense of justification provided by the law, which neither the code nor statutory law defining the offense provides an exception. Okay? Why this is important? Because if we go to the next section, it deals with the justification based upon public law. What New Jersey by statute 47:1A-1, which they were entrusted to protect, which was the incorporation of our society as me being the King of England and my obligations to protect my heirs and our successors and the property that belongs to us. Okay? All right. In order to do that, I had to break their law. And the only way I can do that was based upon this New Jersey by statute, which is actually the statute governing the laws of common law, because necessity and justification is governed under the common law. Okay? They ain't going to put it in a statute, but that's where it is, or that's where it came from. Let's see. Execution of public duty. The exceptions. Except provided in subsection B of this section, conduct is justifiable when it's required or authorized by 1, The law defining the duties or functions of a public officer or the assistance to be rendered to such officer and the performance of his duty. What law is that? Everyone said the common law. Thank you, C.A. Murphy. The common law. All right. 2, the law governing the execution of the legal process. What law is that, y'all? The common law. The judgment or order of the competent court of tribunal. This is the statute. So the court of a competent tribunal must follow the laws of the statute, okay? Which says that there is an exception to those who violate the law if they invoke the choice of evil doctrine, which is based upon the choice of the lesser evil, okay? Very, very, very important for you to comprehend that. The day you see the statute in modern day, New Jersey law governs the justification for the necessity to break their color of law, especially for us as the English Anglo-Saxon Berbers, because the law for us is the English common law, and they're not using that, okay? They're using some other law that they want to say is common to them, okay? So that means that they ain't of our political society, and therefore they can enforce their laws from their society on us. This is what we call diversity of jurisdiction, okay, or diversity of citizenship. We must comprehend. So we just read what the state versus state stated in the Supreme Court of New Jersey, as well as United States versus Lee and United States versus Supreme Court of New Jersey in regards to the law of necessity and the justification for that, which need not to be if the king was here, okay, or any other representative who acted on behalf of the king, especially in regards to what we call property, whether it be chattel, whether it be land. We must understand the language, okay? You will find this nowhere else out there in TV land, okay? So let's understand the necessity of English criminal law that we have just validated in their modern day statute. It didn't say common law here, but if we go to Wikipedia and look at the law of necessity and justification based upon the origin where it comes from, which is common law, especially in criminal cases, it would say everything that we're saying here today. Let's just see. Necessity in English criminal law. It's amazing how many of us are asleep. In English law, the defense of necessity recognizes that there may be situations, okay, of such overwhelming urgency that a person must be allowed to respond by what, y'all? Breaking the law. Okay? Breaking the law. That's right there in New Jersey Revised Statute. Okay? Right there in your statute. I didn't put it there. They put it there. Okay? So if it's there, I didn't come to change the law, but to fulfill the law. You said it. I didn't. In English law, the defense of necessity recognizes that there may be situations of such overwhelming urgency that a person must be allowed to respond by breaking the law. There have been very few cases, i.e. presidents, validating this. Why? Because they didn't want you to know that they was breaking the law, okay? But I just gave you 2 cases, okay? I gave you 2 cases. State versus, what was it? State versus Tate, okay? Supreme Court of New Jersey, and United States versus Lee. All right, let's see. So necessity in criminal law. I need to be writing these terms down if you haven't. And when you write them down, they better be applicable to the common law. Necessity in criminal law. In criminal law of many nations, necessity may be either a possible justification or an exculpation for breaking the laws, okay? Very important. For breaking the laws. Defendants seeking to rely on this defense argue that they should not be held liable for their actions as a crime because their conduct was necessary to prevent some greater harm, and when that conduct is not excused under some other more specific provisions of law, such as self-defense. All right, so we are actually acting in the capacity of self-defense. We are in a state of emergency right now. We have to defend ourselves, whether we were in bondage of slavery or in bondage in the law. Because in the background, you see the ones we had in slavery and the one we have in law. And the one we held in slavery, i.e. the former, was based upon the latter. Okay? So if you break the latter, you break the former. Okay? We must understand how important this lesson is to all of you who are claimed to be English heirs. As a matter of political expediency, states usually allow some classes of persons to be excused from liability when they are engaged in socially used functions but intentionally cause injury, loss, or damages. Did you hear that, y'all? Did you hear that? Okay? Some societies, some classes can be exonerated from such activity. I'm not talking about going and blowing up buildings and things of that nature, etc. All right? Or tearing down public property. We're not talking about that. When we take action based on the law of necessity, it's breaking the laws that were colorable. All right, not about taking action physically, but through the courts. Okay, through the courts, through the public record. Okay, through the public record. The public record allows me to invoke the law of necessity. The public record says I'm the king of England. The public record says you are my heirs. The public record says this is my land. The public record says these is the land that you're supposed to inherit. So I'm obligated, based upon the common law, which they're not following, to break their law because, as Archbishop said in the title of this lecture, it's color of law. For color of people, okay? For color of statuses. We must comprehend. Necessity under tort law. In tort, common law, the defense of necessity gives the state or an individual a privilege to take or use the property of another. To use the property of another is called an easement. To right to use property that you don't own. Okay? And that's usually as a result of what we call it being abandoned. That's called bona vacationia or abandoned property. Okay? Which the state takes. They don't own it. Why? Because they only got it as a result of eminent domain power. Eminent domain power is a result from interstate when there are no heirs. But when there are no heirs, the crown is supposed to take it, and the crown is represented by that individual who personifies the crown by way of what we call a corporation soul, which I fit that requirement. So, based upon the public record, the law of necessity is befitting the justification for my actions. Okay? All right? As well as the actions that any representative or who we represent take on behalf of trespass. Okay? Not just trespassing, but when you trespassed it, you wasted it. All right? You wasted it. You lay waste to the land. You lay waste to the property. You lay waste to the agricultural economic growth that could have or would have benefited those people who were originally there. Okay? We must understand what it is that I'm telling you. Those who laws that we have broken because they have trespassed on us. They had trespassed on the English Anglo-Saxon and enslaved those English Anglo-Saxon Berbers, and they became chattel. We know that because if you go back to my past two prior lessons, it'll tell you that we were in a state of indentured servitude, i.e. Berbers, known as Negro, blacks, colored, and Ethiopian, going all the way back to what we call Sudan, because New Jersey apologized for it. They apologized for the slavery, which were at one time freemen, okay? Whether slaves or free man, we were free from slavery. That means that we had prior to that enslavement, we were free man. But because of the enslavement, we became freedman, going back to the status of freedman. And the only reason why we got enslaved because of invasion. Okay, trespass. All right, trespass. Let's look at these words real quick before we move forward. Okay, what is trespass on chattel? Y'all need to be ashamed of yourself, for real. You all need to be ashamed of yourselves who claim to be dealing with the affairs of men. You should be ashamed of yourselves. Okay? And I say that with a heavy heart. Trespass to chattel, also called trespass to personality or trespass to personal property, is a tort whereby the infringing party has intentionally, i.e., an intentional tort, interfered with another person's lawful possession of chattel, i.e., your personality. Okay? We must understand that. It goes on to say that the interference can be any physical contact with the chattel in a quantifiable way or any disposition of the chattel, whether by taking it, destroying it, i.e., wasting it, or barring the owner's access to it, unlawful withheld, as opposed to the greater wrong of conversion. Trespass to chattel is argued to be an action per se. Okay? So that means that when they trespass on the heirs, they have converted them from being natural people to property, i.e., chattel. Okay? And then robbed them of their personality of who they really was based upon how they were supposed to be identified as free men. Okay? They have converted your minds, brothers and sisters. All right? So there's a necessity for us to break this color law. If you're not going to do it, then I'm going to do it. Okay? All this involves malicious prosecution as a result of invasion of privacy, appropriation of name and likeness. Okay? Defamation of character, putting a false light. All this intrusion of seclusion. Okay? Private affairs into the public light. All this denotes to a malicious prosecution. Okay? Y'all, I'm telling you, this is just life. It's just sad. So we just build trespass on chattel. They can't get the trespass on chattel, i.e., the people, if they didn't get the ability to trespass on the land. So what does it mean to trespass on the land? Let's see. Let's read it. Because apparently nobody else is talking about this. And the only way you can talk about this is understanding trespass on chattel and trespass on land and conversion based upon it going back to what? The common law. Okay? Because the law of necessity originated from the common law. And if you go back to the common law, then the law of necessity, i.e., breaking their law, is justified. Okay? It is justified. Trespass to land are also called trespass to realty or trespass to real property or sometimes simply just trespass. It's a common law tort or a crime that is committed within an individual or the object of an individual intentionally enters the land of another without lawful excuse. You see the gravity of the situation I'm talking about, y'all? Trespass to land is an action per se. Thus, the party whose land is entered upon may sue even if no actual harm is done. This is called waste, treble damages. Okay? This is under the 2A of the criminal administrative statute governing criminal and administrative justice. Okay? Criminal and administrative justice. These are the laws that were initiated and incorporated in New Jersey by William Patterson, the governor who overthrown the crown, okay, and the laws of the crown. We must understand what's at stake, y'all. Okay? So we are able to seek damages and have an injunction put on, but we must act in our capacity, and the capacity is by way of the justification of acting that capacity is by breaking their law. You can't break their law by playing with their law. If you're gonna play by the law, you gotta play by the rules of that law. You must understand. All right. So trespass of land can only happen when the people allow them to trespass on the land. And if that happens, that means that they are able to be trespassed on chattel, because guess what? You now become the chattel. And all this allows them to what we call in the common law the right of conversion. The right of conversion. Anyone know what the law governing the law of conversion? Just look it up. Any questions so far? Any questions? Conversion is an intentional tort consisting of taking with the intent of exercising over the chattel and ownership inconsistent with the real owner's right of possession. Oh, who is the real owner? The king. Who the king represents? The crown. What does the crown personify? Crown land. What does crown land? Intel land, which belongs to who? You, the heirs. Okay? If you ain't there, then that means that the crown had to personify the inquisition post-mortem of the estate as a result of interstate, okay, which is done by what we call escheatment, the law of escheat, to take that which no one owns. Okay, we must comprehend the science. Okay, so conversion is an intentional tort consisting of taking with the intent of exercise over the chattel and ownership inconsistent with the real owner's right of possession. In England and in Wales, is a tort of strict liability. It's equivalent in criminal law, excluding loss or death, and criminal conversion. And those jurisdictions that recognize it, criminal conversion is less crime than theft or larceny. Okay, today you see it. Conversion only comes by way of you having the ability to take what you don't own by way of converting the people who own it into what we call chattel, and then by taking the chattel in the land that belongs to them and making money over it through what we call conversion. This is unjust enrichment. Okay? Unjust enrichment. You better know what you're talking about when you're playing with these people. Okay? You better know what you're talking about. So all this is about the law of necessity. Okay? The law of necessity. I, your king, had to use the law of necessity because people have trespassed on the land that belongs to us going back to what we call time immemorial. And even before time immemorial, let's look at the history concerning the king's overseas possessions, because this is called radical title. Let me just pull this up in case you brothers and sisters never heard this term. This is why you have a republic. A republic is called a commonwealth, okay? And that only results in what we call an interregnum. An interregnum, which means that there is no king, okay? There is no king. Radical title is a concept, once again, no other nation of people here on this planet use these terms pertaining to the law of the land in which they exist on. All right. Apparently, ain't no English people here, but yet they're making reference to these terms here, not just in that land, but overseas. This is called littoral rights and riparian rights. Littoral rights means rights that exist across large body of waters. Okay. littoral rights. All belongs to the crown. Radical title is a concept of English common law that refers to the crown underlying title to all land held in overseas plantations and colonies. It grants the crown the power to alienate, okay, deport, okay, others from the land and to transfer beneficial ownership of the land to itself or others who are heirs. You hear that? But by itself does not grant beneficial ownership. It's preserved. Okay, the crown is indefinite. Okay, it's a royal peculiar. So we understand that the crown, i.e., the king, i.e., the monarch who controls the land by personifying, incorporating it, or incarnating, as you see in your biblical story. This is based upon what we call intel land, because crown land is intel land. And no matter where that land is it on the land in England or it's over here in what we call the overseas possession, it still belongs by the crown. And whoever the crown gave charters to, if you're not living up to it, if you're not managing it right, then you are wasting that land. Not only wasted it, you have trespassed and wasted the land as a result of you not living up to the obligation you have as either a tenant or a landlord. Okay? And as a result, reversion of abandonment is justified. Okay? By way of a necessity. Okay? I ain't got to go to a court. I can do it myself. Just going down into the public record because I have the right to examine the record to not only examine the record but file for the public record anything, because those courts are not courts of record. Those courts are courts of commercial activity. Okay, until I came back up on the scene. Now they have to return back to my court. All right, because I'm the one who oversees, because the power of the bench is in the king's bench. Okay, we must understand that. Let's move forward. So let's go back to the English overseas possessions, which is part of the radical title of the crown, known as overseas plantations and colonies. All right. This is the reason why when those colonies came over, they were called plantations. Okay. This is called the anti what was called the antediluvian age. Okay. The age of the plantations. Okay. English overseas possessions. All right. Let's look at it. Look at the map. Look at the map. On this map, it shows the territories that in the Anglosphere. Let me just pull this up once again. A lot of you might not have seen this yet. I didn't say Anglophone. I said Anglosphere. If you're in the Anglosphere, that means you speak English. All right, because Anglophone has to deal with the language. Okay, Anglosphere has to deal with the geographical area. Okay, and it's very important that you have to understand this, because the Anglosphere not only encompasses North America, but it also encompasses territories in what we call Northeast Africa, all the way from the Nile all the way over to north, the west, west of the Nile, of the Red Sea. Okay, and all this, there was an Anglo, what we call unification. Okay, because it's called the Anglosphere. All right, we're dealing with the Anglospheres and all the territories within the Anglosphere belonging to the crown. Okay, we must comprehend that. The Anglosphere, also known as the Anglo-American world, you hear that? It's the Anglo-American sphere of influence, with a core group of nations that today maintain close political, diplomatic, and military cooperations. While nations included different source vary, the Anglosphere is usually not considered to include all countries where English is official language. This means Anglophone. Okay? As you can see on the map, Over here, the light blue, that's over areas considered what we call Sudan, all right, or Nubia, okay, or Kush, all right. All this is the territory belongs to the Berbers. If we go to the history of the Berbers, they migrated northwest from the Nile, okay. They migrated northwest to west to the Nile. Let's just prove that real quick. Berber. We know the word Amazigh means free people or free noble. Okay, Amazigh. Okay, Berbers or Berber people, also called in Indian Amazigh or Amazigh, are a diverse group of distinct ethnic groups indigenous to North Africa who predate the arrival of Arabs in the Maghreb. Did you hear that? They predate the Arabs in the Maghreb. When we say Maghreb, we mean anything that's opposite of the on the that's west of the Red Sea, not east of the Red Sea, but west of the Red Sea. Anything east of the West Sea is dealing with Arabs from Arabia, and that goes back to what we call Muhammad, the founder of the Arab religion, which is Muhammadanism. Okay, though our ways may be similar based upon the 19th Encyclopedia of Britannica, though the religion or the government or the ways or the political system of these two groups of people, Arabs and Berbers, are similar, they are different. Because it said the Arab was a nomad, but the Berbers, even though he had Mohammedanism ways, his government was called Wittenmart, and his laws or uncoded law was called that of the Magna Carta. Okay? And we understand that we go back to my lesson I did yesterday. I showed you the actual calendar and showed you prior to 1066, there was no English renown year. The only renowned kings that were ruling were Berber kings because there was only a Berber calendar in existence. Okay? It goes on to say that their main connections are identified by the use of the Berber language, which apparently must be English because these are English letters. Most of them mutually unintelligible, yeah, as you might say that, which are part of the Afro-Asiatic language family. So when you go back to those who interpret the history of those people living in that territory known as Kush, known as Nubia, known as Sudan, then it might be a little ambiguity or a little confusion in it because, as I say, he who writes your books set your timeline. Okay? He who writes your books set your timeline. So we were called by many different names, but the name that stands out is the Berber because Berber has a calendar. Okay? No matter wherever geographical location that they were found in. Okay? We must understand that because this goes on to say that Berbers descended from the Stone Age tribe of North Africa. Accounts of the Amazigh were first mentioned in ancient Egyptian record from about 2000 BC, which means the Berber calendar. Berber languages spread westward from the Nile Valley across to the northern Sahara and to the Maghreb. You hear that? It didn't mention anything about Arabia. It said from the Nile Valley across to the Sahara and the Maghreb. If you go back to where would we at? Anglosphere, you see it right here. See it right there. The Nile Valley, all right, northwest to the Maghreb. This is all the Maghreb, all right. This is the land of the Berbers, as well as those Berbers on the Iberian Peninsula, as well as those Berbers who are over in the territory now known as United Kingdom, prior to that called Great Britain, prior to that called the Kingdom of England, prior to that called Albion, as well as those here in North America, which was an extension of those lands governed by what we call the English overseas possessions, okay, under the King's radical title. Once again, under the King's radical title. Let's see, because the English overseas possessions are part of the English overseas possessions under the radical title. The English overseas possession comprised a variety of overseas territories that were colonized. You hear that? conquer, or otherwise acquired by the Kingdom of England before 1707. So we know we didn't get the unification of England, Ireland, Scotland till 1707. We didn't get a unification of the crown till 1603. We didn't get the Treaty of Perpetual Peace till what we call what was it? In the somewhere around 1532 between Henry VIII and the Kings of Stuarts, King James III and King James IV. All this time we had the war originate between what we call the 100-Year Wars, which originated between the Capitan and the Plantagenet dynasty, going all the way back to the conflict that we talked about in my past lecture, going back to what we call what was it called, what we call the Old Alliance or the Old Alliance. Okay, the Old Alliance was the alliance between the opposite dynasties, those who descended from Muhammad from the Arabian Peninsula, and those who aligned with themselves, such as the Arabs from the opposite dynasty, as well as the Scottish. Okay, such as the kings of Great Britain, who didn't come to their power till 1707. Okay, but we understand that when we go back to their original conflict with England, it goes back to their expulsion from England. Okay, they were expelled in England in 1295 through the edict of expulsion by the Plantagenet King Edward I. Okay, Edward I of the Plantagenet King expelled them. Okay, so the English overseas possession was comprised over the overseas territories all over the world. All right, based upon it being an English empire, because before it became a British empire, it had to be an English empire. Okay, before it became an British empire, it was a French empire or a Spanish empire, but the English empire precedes them all. Okay, the English empire precedes them all. And when I say the Spanish, the French, the British, the American empire, we're talking about the empire right here in what we call North America, because New Spain, New France, Great Britain were all over here in North America as a result of them occupying or what they're saying, trespassing on these lands, okay, and enslaving the peoples on this land, okay, by way of trespass, acquisition of sovereignty, and claiming to be the sovereign, but you are not, okay, because if they were sovereign, they would still be here. Let's see. The origin of the English overseas possessions. Let's go through it. Origin. In North America, Newfoundland, and when you go to Newfoundland, you go back to New Netherland. New Netherland goes back to the Dutch. Okay? Once again, you go back to Newfoundland, Amsterdam, Newfoundland, Netherland, Dutch. Same family. Okay? All these goes back to your Danish Vikings, okay, or your Danish kings, going all the way back to the time of Harold Godwinson, okay, which we're going to talk about today. I know the whole genealogy. I can connect the whole genealogy based upon the law, okay, all governing the law of necessity and justification for the law of necessity, i.e., are breaking the law, okay, because when they conquer, they put in their law. So in order to restore our law, we have to break theirs, whether we're in England or whether we're here, because being that we are descendants. So it said in North America, Newfoundland and Virginia, for the first centuries of the not English colonization, parts of, yeah, they said it right, of the English colonization, meaning those people who colonized on English soil, okay? So the English colonization was based upon British who posed to be English, posed themselves as English here on this soil, okay? Because we know that the first English renown year didn't come until, well, who? William the Conqueror. So it's appropriate to say that. William the Conqueror came in 1066. Prior to that, every king that was ruling in England were Berber kings, because the only county you have, or the only renowned king you had, was Berber king, okay? So it says, during the 17th century, Maine, Plymouth, along with Newfoundland and Virginia, New Hampshire, Salem, Massachusetts, Bay, Nova Scotia, Connecticut, New Haven, Maryland, and Rhode Island, the provinces were settled. In 1664, New Netherland, you hear that? New Netherland, the Dutch, the Danish, and New Sweden were taken from the Dutch. You hear that? There we go, Dutch. Becoming New York, New Jersey, and parts of Delaware and Pennsylvania. Just recall West Jersey and East Jersey and West Jersey. East Jersey was Perth Amboy, and West Jersey was Burlington. This is where the seat of Crown was ruling when it was under the Crown. When Queen Anne restored it, once all the charges were revoked, that was going back to the feudal tenure, going back to William the Conqueror in 1066. So the land was remained intact and remained allodial because all the feudal tenures, i.e. the charges were divvied out, were revoked. Okay, the land remained allodial and remained under free and common soakage because there was no heirs to give it to. All right. So the origin of the English overseas possessions, going back to the radical title that was controlled by the crown, goes back to the Kingdom of England and generally dated from the rule of Asherton, okay, from 927 to the rule of the House of Ningler. These are Danish kings, okay, from 1013 to 1014 and 1016 to 1042. England was a part of a personal union that included domains of even Scandinavia. And 1066, William the Conqueror, Duke of Normandy, and conquered England, making the Duchess of Crown Land of the English throne. Through the remainder of the Middle Ages, the Kingdom of England held extensive territories in France. Okay, this is when we start going over there. All right, in France, based on their history in the duchies under the Angevin Empire. England formed part of a collection of lands in the British Isles and France held by the Plantagenet dynasty. The collapse of this dynasty led to the 100-Year Wars between England and France. Not over there, but right over here. Okay? Not over there, but right over here, which is the reason why we have to go back to the laws of necessity because of the trespass on the chattel, because of the trespass on the land, and the conversion of the chattel and the land to benefit them. All right, let's get to it. We know Asherton was the grandson of who? Alfred the Great. Okay? Asherton was the son of Alfred the Great. Alfred the Great were warring with Danish kings. Okay? House of Ninglinga. The Danish House of Ninglinga were a ruling royal house of Middle Age Scandinavia in England. Did you see that, y'all? Did you hear that? Going back to Canute the Great, okay? This is going back to Canute the Great. They were Danish Vikings, but they aligned themselves with what we call the kings of Wessex, okay? The kings of Wessex, all right? This came as a result of what we call the unification of the Heptarchy, okay? The 7 kingdoms, all right? The 7 kingdoms. Let's move forward in this lecture, all right? So let's go back to Alfred the Great, the grandfather of Asherton, who controlled the English overseas possessions over their radical title as a result of what we call the English common law, okay, which is the supreme law of the land, okay? And they kept invoking the laws of necessity for justification as a result of invasions of people who came in and put in their de facto laws. Let's get an example of the justification of the necessity of laws to break the laws, going all the way back to the Treaty of Alfred the Great. Okay? Let's just see. Everybody like what you're hearing? Please give me a thumbs up in the chat. Please give me a thumbs up in the chat. War, peace, and diplomacy in the Middle Ages. Okay? Alfred Guthrum and the justification of necessity. We see that statue right here in New Jersey by statute 2C:3-2. It mentions the word necessity and justification under the same breath. Didn't it say that? Let's just say it real quick. Look at it, y'all. Look at it, y'all. You can look at it or close your eyes. Whether you close it or open them, it's there. Okay? Necessity, other justifications in lieu of breaking these laws that we're subject to. It's right there in the statute. And because this is a common law statute going all the way back to who? The Treaty of Alfred and Godfrey. Because Godfrey was a Danish Viking who invaded England and set up their own laws by supplementing and amending the laws that were there prior. Okay? Pretty much what you have today. Okay? Pretty much what you have today. Let's go back to the War and Peace and Diplomacy in the Middle Ages. Everybody hold that thought. Alfred Guthrum's and the Justification of Necessity. So that means that statute 2C:3-2 and 3-3 is talking about the statutes that were incorporated or amended or supplemented based upon going back to the origin of the laws created from the original statutes as passed by our ancestors, Alfred the Great. Okay, as a result of Guthrum. All right. So Alfred's conflicts that were resulted by way of initiation that resulted from war and diplomacy with Vikings. All right, pretty much what you got going on today. Okay, because the majority of those who took the land by barbaric ways, by force, and they can either do by way of physical force or legislative force. All right, you are a Viking. You are a barbarian. There is no justification for what your laws that you have created outside of the laws exist. Okay, we must comprehend. Right there. Let me blow it up so you brothers and sisters can see it. All right. Everybody hold that thought. July 25th, 2020. Alfred Guthrum and the Justification of Necessity. The treaty between Alfred and Guthrum, concluded in the late 9th century, has attracted a lot of attention from scholars, with the discussion frequently focused on the so-called border. Hear that? Border, described in the text as dividing their two kingdoms. Okay? Less attention has been paid to the fact that it is the only English treaty to contain a reference to a necessity as a justification for action. Did you hear that? Everything that's going on right now concerning the border is a justification for why the law has to be restored. Because the laws that New Jersey go by, or any state within the United States go by, was based upon foreigners or immigration. Okay? All right? It was based upon that. What Trump trying to do, he's trying to change those laws to maintain the border. Okay? But what laws are he trying to use or pass to maintain it? It ain't the original laws that were passed by our ancestors. All right? So we must understand that though those changes may help, but it's still going to cause greater harm to those who are here on this land as a result of not understanding the common law of England. Because he's not using the common law of England based upon the ability to be able to use the law of necessity and the justification for his actions. Okay? He's not doing that. So we have to do that. I have to do that. Those who represent our kingdom must do that. So the treaty between our ancestors, Alfred and Guthrum, not an ancestor, concluded in the late 19th century and has attracted a lot of attention in this present day from scholars, not scholars, but lawyers, judges, uh, uh, spokesmen, etc. And the discussion frequently focused on the so-called border, described in the text and as divided their two kingdoms. Less attention has been paid to the fact that it's the only English treaty that contained a reference to necessity as a justification for action. You hear that? A justification for action. As explained previously, necessity was used to protect basic values and fundamental interests of the ruler, his people, and the entity they inhabited. Did y'all hear what they just said? Did y'all hear what they just said? So why you think I'm doing what I'm doing? To protect the corporation soul, which represents the Kingdom of England, the crown land that is supposed to protect, as well as the heirs, okay? Based upon us protecting our basic customary values, which is what? The law. It is a necessity that you obey the law, okay? Not break the law, but obeying the law. But in this case, breaking their law is obeying our law. So if you're not down with us, then that means that you're breaking our law and obeying their law just because you're going to stay mute, okay? Just because you're mute. Action speaks louder than words. Okay? We're reading words right here. These words came from their actions. Okay? So where are your actions from your words? I'm showing you my actions from my words. Okay? We're showing you our actions from our words here at the Third Temple English Church of England. Going back to the time of the English Reformation that was rooted in or grounded in the restoration that was done by who? Alfred the Great. Alfred the Great, who was in fact a Berber. He was a free man. Okay? The 1911 encyclopedia says that the government of Witteman and the customary laws of the Magna Carta was that of the Berbers. And the word Berber, according to Amazin, means free man. Okay? Free man. Okay? So when you go into the treaty, the last clause, he don't use the word Anglo-Saxon. He don't use the word Berber. He used the word free man, contrast to the word slave. Even though slave or free man, because we know we denote that word slave is a status, okay, of citizenship, okay, here on the land, all right. Whether you were a nobleman, being that you were part of the royal family, or you were part of the military, i.e. a knight, or whether you were a peasant that worked the land, all right, this is the whole basis of the checkerboard, okay? The whole chessboard is based upon, not the checkerboard, the chessboard. The chessboard is the allodial land. Each box on that checkerboard represents feudal tenure, okay? All right? Prior to it, we call it feudal tenure, i.e. the X was called a land tenure. All right? Each box and square is a land tenure, and if there's nobody sitting in that box, that means that it represents that the land tenure has not been given to the heir. That means it represents interstate. Okay? Not parts of that interstate, it represents post-mortem, meaning that that child is not the age to be able to inherit his estate, which means that it remains with the crown or the king until he becomes to the age where he can inherit the state by being primogeniture, by being what we call birthright. Okay? We must understand that. All right? So the law of necessity was used to protect basic values and fundamental interests of the king, the monarch, his people, the heirs, entail, and the land in which they inhabited. I.e., the land is the lolio because the king owns the lolio. If there's a land tenured out under that lolio land, it becomes what they call a land tenure. The only way it becomes a feudal tenure when somebody owned that land, which is not the original king. All right? The one who's not the king is what we call William the Conqueror. So once again, you go back to the chessboard. The chessboard only has one land on it. But there's two individuals on either side of the board, all right, arguing for possession of the land. Okay? one person actually owned it and the other person trying to make a claim in it, whether it's by discovery, whether it's by conquest, whether it's by eminent domain power, whether it's by adverse possession, somebody's making a claim on it based upon some operation of law. Okay? We must understand that. All right? So if that's the case, then the only person that can make a claim to it is either the foreigner or the national. Okay? Either the foreign or the national. And we understand that the king of that kingdom and the representative of the nation as permanent patriarch, he's sitting up there in that big ass castle. Okay? He's sitting there in that castle. All right. And in that castle, he had his family called the royal family, such as the queen, the prince, other noble, etc., as well as other members of his council, i.e., the king's council. This would be what we call the bishops, okay, his clergy. Along with them, it'd be his military, his knights. Inside the castle and outside the castle, that's the military force who patrols the land, okay, the estates and lands, and make sure that the people who till the land, i.e., those who were allowed to be on the soil, have the right to the soil to yield and harvest their crops. Okay, this is what the agriculturalist does. Okay, and if somebody else comes on the land and try to take that possession from you and try to use it for a conversion, because now you no longer have the rights to do as intended based upon the original granted from the king. Somebody else is posted on the king because there's somebody else on the other side of the board with their own family members, their own military, and their own clergy, and their own peasants, etc. And they want a part of it as well. So this is why necessity as a justification for action is needed, okay? For the whole, not just for you, the king, but for the whole. Hell, if the king goes, then everybody's doomed. That has been the situation that you have been in thus far. It was stated in Supreme Court, United States State versus Tate, as well as United States Supreme Court, United States versus Lee. Okay? The law of necessity is not needed when you got a king or any representative on behalf of any property. If there is no king or no representative in regards to the property, then that means that somebody acting on behalf of that property that was taken from you had to lose the laws of necessity, okay? Which is a justification because somebody has taken your property, okay? So, and holding your property by some law they set up to maintain it. So you have to break their law. That's called the law of necessity. The justification for breaking their law, which is a necessity. And we know the word necessity means needs to be done. It needs to be done. Okay? Let's go on. All right. So let's go to the Treaty of Alfred and Guthrum. All right. The Treaty of Alfred and Guthrum. All right. In 866, the great heathen army landed in East Anglia with the intentions of conquering all the English kingdoms. During its campaign, the Viking army conquered the kingdom of East Anglia, Mercia, and Northumbria, and initially overran the kingdom of Wessex. But Danish King Guthrum was defeated by Alfred's army at the Battle of Edington. In 878, under the terms of the surrender, shortly after, Guthrum was obliged to be baptized, okay, to endorse the agreement as well as to allow him to rule more legitimately over his Christian vassals, but remain pagan, i.e., slave to his pagan vassals. He was then with his army to leave Wessex, i.e., deported. That agreement is known as the Treaty of Wetmore. Everybody understand that? Let's go into the actual treaty and see why it's important. A translation to the modern English of the treaty between King Alfred, King Guthrum of 878 and 886, with some notes below with some of unfamiliar vocabulary. It says, this is the peace with King Alfred and King Guthrum, and the wise men of all Englishmen, i.e., the king's Council. Let me just go back to 1911 Encyclopedia just to pull this up. If nobody else is talking about this, and all of a sudden now we incorporate the Anglo-Saxon Berbers, and all of a sudden now we're taking action based upon the necessity of the cause of action, and is justifiable based upon this necessity as a result of the greater harm. Okay, as a result of the greater harm. So here we have the 1911 Encyclopedia Britannica from Edinburgh, Scotland. We know Scotland and Edinburgh is where those monarchs who invaded England came up with this detailed description of the two Anglo-Saxons. Okay, all right. They said right here, the Arab is a herdsman and a nomad. The Berber is an agriculturist and a townsman. The Arab has built his social structure on the Quran, which inculcates absolutism, aristocracy, and theocracy. The Berber, despite his nominal Mohammedanism, is a democratic, with his Jimna or Wittenma and his Qanun or unwritten code, the Magna Carta, of the individual's liberties as opposed to the community's good. Okay? So we must understand that when we're talking about Alfred the Great, when we're talking about the laws of his ancestors, his predecessors, his successors, we have to go back to the characteristics of those people who made those laws. And we see here it says that they are in fact Berbers, not Arabs. And we know that Berbers were in the Nile Valley, as well as going all the way back to Northeast Africa, called the Maghreb, going all the way back to the ancient Kushites, called the ancient Nubian, or the Black Pharaohs, which goes back to what we call the 22nd, 23rd, 24th, and 25th dynasty, which we'll call the ancient Kushite. And Kush is an English word, as well as Berber is an English word. Okay, and the word free man is an English word. Okay, free man is an English word. Let's look it up. Free man. Because this is the word, this is what Alfred the Great used as the characteristics. Okay, he stated in the black law, parts of in family crest and coats of arms, because remember nouns are persons, places, and things. So the name free man was a name given to a place. It was a name given to a thing. It was a name given to a person. Okay. We understand that black is a name given to a person. Black was a name given to a thing. It was not. It was a name given to a place because the land, Sudan, which is called the land of Nubia, which is the land of the Black Pharaohs, was a term given to the people who lived there, denoted or characterized as Black Pharaohs, but they had a nationality. And in Sudan, they got a territory in Sudan, which was originally called Nubia or called Berber. Okay, and Berber is just a term that denotes what we call free man. Okay, or freeborn. All right, let's look. Freeman, history, family, crest, and coats of arms. The surname Freeman is an ancient Anglo-Saxon name whose history dates back to the days of the Norman conquest of 1066. So prior to Norman conquest coming here and being the first English renowned king, and all those after him was English renowned king, prior to them they were all Berbers, and yet the word freeman goes all the way back to 1066, and we know that prior to 1066, the only calendar that existed prior to the English renowned year was the Berber calendar. This is why Alfred the Great denoted to his people as freemen, because he was the father of who? The Anglo-Saxon. And the Anglo-Saxon were tribes of Berbers, okay? The surname Freeman is an ancient Saxon name which history dates back to the days before the Norman conquest. Before the conquest, the name is derived from freeman or Frenchman, or English word for a person name meaning free-born man. Did you hear that? Free-born man. So let's go back to the time of the Treaty of Goldsmith and the language in the charter pertaining to those who weren't free-born man, because if you were a free-born man, then you would not be a Viking, okay? If you were a free man. Free man denotes to having a nationality, all right? Free man denotes to being born by blood, not just because you immigrated somewhere and they have children on that shore, okay? you still are a foreigner. You're not a free man. You're subject to the laws of that land, whether you like them or not. Okay? So by being nationals, the laws that are imposed upon us on this land, it was a necessity of us for to break those laws, all right? Which is offensive to them. Why? Because this is what they go by. But it does not preserve our rights as free men. Those laws pertain to slaves, okay? Bondage and chains or on paper, okay? Based upon the status. So we are obligated based upon the necessity to break that law, and the law is justified based upon the law of justification and necessity, going back to who? Alfred the Great. Okay? Because the word necessity means what? Needs to be done. Needs to be. Okay? Let's go back to the article. So we can, in fact, agree that Alfred the Great, as one of the wise men, because Whitman or Whitman means wise counsel. Okay? Wise men or wise counsel. Okay? This is the peace which King Alfred the Great and Guthrum and the wise counsel of men of all English kind. You hear that? Of all English kind. I didn't say Danish kind. It said English kind. And all inhabitants that are in East Anglia, meaning recent settlers and people long settled there. You hear that? Have all agreed on and confirmed with oath for themselves and for their followers, born and yet unborn, who want to have God's mercy on ours. Did you hear this, y'all? Did you hear this? All right. First, concerning our boundaries up the Thames and then up to Lear and along the Lear and to its sources. And now we understand that when we go back to not just there in that territorial, but as well as the overseas territorials that are based upon littoral rights, okay, which were territories that involve plantations and colonies that were set up by way of charters granted by the king, okay? So it says, next, if a man is slain, all of us estimate a noble Englishman and a noble Danishman at the same amount at 8 half marks of pure gold, equivalent to 1,200 shillings. But the freeman who occupies rented land and the Danish freeman are both estimated at the same amount, 200 shillings. This is based upon the treaty. Okay? This is all based upon a treaty. Now we understand when we go back to the history concerning the Danish and the Englishman were living side by side together. Okay? They were living side by side together. Why? Because we know that Danish goes back to the Vikings, going back to Harold Godwinson. Okay? Matter of fact, let's prove it. But let's go to the closing of this the last chapter of this treaty before I move forward. Right here, key point. All in lieu of what we call necessity, justification for necessity, i.e., to break the law. Okay? If you break the law, it's a result of a breach of contract, because contract makes law. Okay? So it's a necessity to break the law when there's a breach of contract, and the breach of contract justifies the breaking of the law. All right? It says, and we all agree on the day when the oaths were sworn that no slave or free man, i.e. Berber, as well as Viking, go over to the Danish, that is to visit or settle in Danish territory without permission. And no Danishmen are to come over to us, that is visit or settle in our territory without permission. But if it happens that any Danish necessity or wants to trade with us or we with them for livestock and goods, that is to be permitted on conditions that surety should be given as a pledge, i.e. oath of peace, and as evidence that whoever is involved in the transaction has a clean back. Okay? Has a clean back. That is the law of necessity. All right? To break the law if the law is unjust. Okay? To break the law if the law is unjust. to also break the law if the law which governs the contract has been broken. Okay? Because it's unjust to break an agreement between two parties, stipulating the actions of both parties concerning the status of both parties pursuant to the laws of both parties, especially the laws governing land, which apparently they both got different laws governing both lands, the Danish lands and the English lands. Okay? Come on, y'all. Y'all got to agree with me. All right. So he referred to his ancestors, Alfred the Great, based upon the treaty, and the treaty worked out in favor of Alfred the Great. Okay. And he said that no slave or free man might go over to Danish man. That means that all those slaves who were now freedmen were emancipated. Okay. All those slaves became emancipated as freedmen because they were enslaved as slaves by the Danish, who were the Vikings who invaded the land of the freedman. Okay, according to 1911 Encyclopedia, were clearly Berbers because they ran under the government called Wittemont, and Wittemont means wise counsel. Okay, wise counsel. Y'all ain't listening. Okay, where else can we go? So we understand that Alfred the Great made a treaty with the Danish kings, Guthred, based upon the law of necessity and justification for using the law of necessity if somebody broke the law. Okay? If somebody broke the law. Very important because we are those Anglo-Saxon Berbers who descended from Alfred the Great. And we're letting you know that we're applying the law of necessity, which is an ancient law based upon the institution or the implementing by way of amending, substituting, or a law that denotes to the actions of necessity and is justifying of necessity, which means to break the law. All right, based upon a tort that's committed upon you, which caused you to be the person in error, i.e., the defendant. So therefore, in order for you to justify why they claim you to be a defendant, you must justify that by way of the law of necessity, which means that you had an obligation to break their law. We're proving that us as English, Anglo-Saxon Berbers have the right to break the law of anybody who comes over here and create their law of their own, which is not the law of this land. Okay? We must understand this. Let's see. Let's come to our conclusion. King Guthred, a Danish king, all right, was the king of the kingdom of East Anglia. Okay? Let's review that real quick before I come to my closing. The kingdom of East Angles, and formerly known as the Kingdom of East Anglia, was a small independent kingdom of Angles during the Anglo-Saxon period, comprising of what are now known as English counties of Norfolk and Suffolk, and perhaps the eastern part of the Fens, area still known as East Anglia. The kingdom formed in the 6th century in the wake of the Anglo-Saxon settlements in Britain and was one of the kingdoms of Heptarchy. Okay? Heptarchy means the 7 kingdoms. All right? Combining both the 7 kingdoms. And they all came to the head under King Edgar, the Jesus Christ who won the reincarnation of, because they all paid homage based upon the coronation of King Edgar the Peaceful down the River Dee. Okay? And all these Danish, Saxons, Scottish kings gave homage to our Jesus Christ. Okay? Our Jesus Christ. So we see the kingdom formed in the 6th century in the wake of the Anglo-Saxon settlement of Britain was one of the kingdoms of Heptarchy. It was ruled by Wolfingus dynasty in the 7th and the 8th century, but the territory was taken by Offa of Mercia in 794. Mercia control lapsed briefly following the death of Offa, but was reestablished. The Danish great heathen army landed in East Anglia in 865. After taking York, it returned East Anglia, killing King Edmund the Martyr and making its Danish land in 869. After Alfred the Great forced the treaty with the Danes, East Anglia was left as part of Danes law. Now, this is when Danes became a part or followed the laws of the kings of Wessex. Okay? We can prove this. All right? Let's prove it. If you go to the kings and the kings of the Danish kings, all right, the 16th of the Danish. Wait 1 second. Let me find it. Okay. So we see that the kingdom of East Anglia was under what we call Guthrum, who made a treaty with the English king, King Alfred the Great. All right, which is called a treaty of peace. All right, and it's based upon the law of necessity and the justification. If somebody broke that treaty of peace. All right, all right. So we must understand that, and we know that Alfred the Great unified all the kingdoms known as the Heptarchy. 7 kingdoms: Wessex, Mercia, Anglia, Norfolk. All these kingdoms. Let me go back there real quick. Heptarchy. Let's look at that real quick. Before I come to my closing. The Heptarchy is a name for the division of the Anglo-Saxon England between the 6th and the 8th century into petty kingdoms. Conventionally, the 7 kingdoms of East Anglia, Essex, Kent, Mercia, Northumbria, Sussex, and Wessex. The term originated with the 12th century historian Henry of Huntingdon. It has been widely used ever since, but it has been questioned by historians as the number of kingdoms fluctuated. And there was never a time when the territory of the Anglo-Saxons was divided into 7 kingdoms, each ruled by one king. The period of petty kingdoms came to an end in the 8th century when England was divided into 4 dominant kingdoms: East Anglia, Mercia, Northumbria, and West. From the Heptarchies, from 7 to 4, and it broken down to 1 kingdom, and that 1 kingdom came under the reign of Alfred the Great. Okay? Alfred the Great. Let's see if we can get that before we move forward. Let's qualify it. All right. Apparently not in this one. Let's go here. All right. So we understand that based upon the kingdom of East Anglia, the kingdom of East Anglia was a result of the invasion of Vikings, which were associated with what we call the Great Heathen Army. And the Great Heathen Army somehow domiciled there and incorporated some of their Danish laws. Okay, that's why a treaty had to be made, but subject to the laws governing necessity. Okay, and the justification for the necessity once that law was broken by either party. Okay, called contract law. Is also subject to what we call the statutes of frauds. Okay, the statutes of frauds. So based upon that, we go to what we call Edward the Confessor. Okay, Edward the Confessor. Edward the Confessor was the son of Ethelred the Unready. Yeah. All right, here we go. Can't get no better than this. Edward the Confessor was an Anglo-Saxon king and saint, usually considered the last king of the House of Wessex, and ruled from 1042 until his death 1066, when William the Conqueror invaded. All right. The coronation chair that all kings take their coronation was named after who? Edward the Confessor. All right. Goes back to the stone of throne, or Jacob's stone, going back to Jacob. All right. The one who had a dream on the stone when angels going up and down the ladder. That's where that story comes from. All right. All Scottish folklore, or what we call folklore created by the Scottish who claim to be the children of Israel. All right, due to what we call the Scottish diaspora, which originated from the Jewish expulsion from the Holy Land. Okay, we must understand this. I don't got time to break that down. I've done in prior classes, and you got to go back hundreds of lectures to find that one, but it's there. So Edward the Confessor was not only a king, but he was a saint. Okay, he was the son of Jesus Christ's son, Ethelred the Unready. Okay? Edward the Confessor was the son of Jesus Christ's son, Ethelred the Unready, meaning that he was ill-advised. Okay? Ethelred the Unready was the one who was selling off Falkland and giving it to what we call those what they call secular clergy, okay? Versus how it was supposed to be originated based upon the monks that were established by under the Benedictine Reform, okay? And this is why the English Benedictine Reform had to be done by King Edgar the Peaceful. And as a result of that, it was overthrown again by what we call the English Reformation by Henry VIII. And as a result of that, you had the Reformation by the Protestants, which succeeded that. And as a result of that, we had to reform it by way of incorporating at the English Third Temple Church of England, reformed from the English Church, which was in line with the English Benedictine Reformation of King Edgar the Peaceful, which was all in lieu of the crown. Okay? We must understand that. All right? So in closing, Ethelred the Confessor was not only a king, but was a saint, and he was the last English king and saint of the kings of Wessex before it went over to what we call the Danish kings. Okay? That's when Alfred the Great made treaties with Danish, and the Danish honored those treaties, all going all the way back to what we call Ethelred the Confessor, because Danish ruled after that. Okay, it said Edward was the son of Ethelred the Unready, and Ethelred the Unready was the son of who? Let's look at it. He was the son of King Edgar, English. That's Jesus Christ. All right, so we all connected. This is God's family. And Edward the Confessor was a saint, and he was the son of Ethelred the Unready, who must have been a saint, and his son was he was the father, son of King of the People, which is Jesus Christ. Okay, we must understand what's going on, and we know that Jesus grew up in what? Glastonbury. Edgar the Peaceful and King Edgar was born in what? Glastonbury. Okay, we must understand the story. We must understand the connection. All right, let's move forward. Edward the Confessor. All right. He was married to a French woman, Emma of Normandy, a Frankish king. Okay. Through marriage. Well, all right, let's go back here. Edward the Confessor. Edward the Confessor was the son of Ethelred the Unready, the son of King Edgar the Peaceful, which is Jesus Christ. He was the king of England, but he was succeeded by who? Harold II. Harold Godwinson. Okay? Harold Godwinson. How many of you know who Harold Godwinson is? Let's see. Harold Godwinson. Harold Godwinson, also called Harold II, was the last crown Anglo-Saxon English king. Harold reigned from the 6th of January 1066 until his death at the Battle of Hastings on the 14th of October. The decisive Battle of Norman Conquest, Harold's death marked the end of Anglo-Saxon rule of England. You hear that? The end of the Berbers' rule in England, not just over there, but over here. Okay? We must comprehend that because we understand that in 1066, William the Conqueror was the first English regnal year. In 1065, the only regnal king that were ruling at that time, if there was no English regnal year, was Berbers. Okay? So Edward the Confessor on back were called Berbers because it said right here, Harold Godwinson was a member of a prominent Anglo-Saxon family with ties to the Danish kings. Okay? He became a powerful earl after the death of his father, Godwin, Earl of Wessex. After his brother-in-law, King Edward the Confessor, died without an heir on the 5th of January, 1066, the Wittemont convened and had chosen Harold to succeed him. He was probably the first English monarch to be crowned in Westminster Abbey. So Wittemont, Witten means wise counsel, and the 1911 Encyclopedia Britannica said there was what? Berbers. Let's just go back to the 19th Encyclopedia. Berbers, Wittemont, right there. Okay? Right there. It's not gonna get any better than this, brothers and sisters, I promise you. It's not gonna get any better than this. So back to Harold Galveston in closing. Howard Galveston descended down from a prominent Anglo pardon, so what happened? Howard Galveston became a member of the Council of Wittemont as voted by Parliament. All right, and he wasn't even an heir by blood. Okay, he was the heir by being born on the soil. Okay, as a result of treaties going back before his birth, the Treaty of Alfred the Great and Guthrie. Okay, we must understand that. All right, we must understand what's going on. So, in closing, where do I want to go? Okay, yeah, all right. So we say that uh Howard Galveston ruled in 1066, and it was the end of the Anglo-Saxon rule. And he was succeeded by William Conqueror. Do you hear this? Harold Galveston was the last king that was chosen by Wittemont. Okay? That was chosen by Wittemont. The Berber government, the Berber representatives chose Harold Galveston, all right, who succeeded Edward the Confessor, the son of Ethelred the Unready, the son of our Jesus Christ. Okay? Very important that we understand that. All right? Howard Galveston, William the Conqueror, succeeded Howard Galveston, all right, when he invaded England in 1066. But uh, um, Howard Galveston was already in England and before 1066, okay? Because he was chosen by who? Wittemont. But all of a sudden, who comes in and invades England? William the Conqueror in 1066. So let's go to 1066 because we know that at the time in 1066, Edward the Confessor, a Berber, all right, chose Howard Galveston. And after Howard Galveston entered the Anglo-Saxon rule in England, then they were replaced by William the Conqueror, where you get the first English now reading out year. Okay, so let's go to 1066. In closing, I want everybody to leave a comment in the comment box, not the chat, but the comment box on how good you thought this class was. Please be informative. Once again, after this lesson, I want everybody to tap a statement in the chat box, not the chat box, the comment box. All right, not the chat that you're on now, but after the lesson's over, type a comment in the comment box and let me know how good you enjoyed the lesson and what did you learn about the lesson. Okay, so in closing, in 1066, all right, we see here Folk the fourth, Count of Anjou, known as the Corolla, is at war with his brother Godfrey. Now, I descended down from the fifth Count of Anjou, Folk the fifth. Folk the fifth was the father of Godfrey, the fifth Count of Anjou. Points up. Folk the fifth was the father of Godfrey, the fifth Count. Points up. I keep saying it wrong. Godfrey, the fifth Count of Anjou, was the son of Folk, the ruler of Jerusalem. All right, his name was Folk the fifth. Folk the fifth descended down from Folk the fourth. They were from the house of Incaler. All right, and they were warned amongst themselves as a result of conflicts where people trying to get into the family. Okay, all right. So you must understand that in 1066, while my family or internal families fighting, the relative families going, which were related by the kings of Wessex, were fighting amongst themselves with other invasions of Vikings who were trying to get into the bloodline. okay, and received the estate which was not preserved for them, okay. So we see in the year 1066, you see the year English read now year. William the Conqueror, all right. Prior to William the Conqueror, uh, uh, Edward the Confessor was ruling, all right. Edward the Confessor was succeeded by Harold Godwinson, all right. But at the time of Harold Godwinson was ruling, there were only Berbish kings, because if you go back to the year 1065, you don't see an English read now year, okay. You do not see an English read now year. Let's pull it up before I close out. Right here. In England, December 28th, Westminster is consecrated by King Edward the Confessor. Okay? Edward the Confessor, the son of Ethelred the Unready, the son of King Edward the Peaceful, who was our Jesus Christ, which I'm the reincarnation of, and his present day, who looks just like me. So how come I know this? Why? Because that's me. All right? And King Edward the Peaceful was a Berber. Okay? Because you see in 1065, when Harold Godwinson inhabited the throne from Edward the Confessor, there is no reading out year here being initiated. It's all Berber, baby. All Berbers. Okay? Right there. All right. And the 1911 encyclopedia was suspicious. It said the Witteman government was Berbers. It was Berbers. Okay, so based upon this lesson, and if you comprehended this lesson, based upon the law of necessity and justification for the law of necessity, i.e., meaning to break the law, is simply as a result of foreigners, invaders, conquerors coming on the land that belongs to you, my heirs, my successors, on behalf of our predecessors, all right, have taken you, my heirs, and made you as chattel. Okay? That's an invasion of your privacy right by appropriation of your name and likeness outside of who you truly are. English people. And the only way they can do that was to trespass upon the land through acquisition of sovereignty, which I'll close out on that. And when they did that, that was a trespass on the land. And when they was able to do that, they started converting the land and the chattel, i.e., the English people, and start using them for their own purposes. All right. So in closing, I'll pull up one more topic or term: acquisition of prescription. Prescription. This is how they doing it, brothers and sisters. This is how they stole your estate, by creating these laws, okay, and imposing these laws on the inhabitants, okay? That's a trespass. All this done is by prescription of sovereignty transfer. They claim to be the sovereigns when you are actually the sovereigns in your personal capacity, in your private capacity, because you descend from sovereign kings. All right. So prescription of sovereignty means prescription in international law. It's a sovereignty transfer of a territory by open encroachment by the new sovereign upon the territory for a prolonged period of time, acting as the sovereign without protest or other contest by the original sovereign. It is analogous to the common law doctrine of easement by description by private real estate, for private real estate. The doctrine legalized de jure. The doctrine legalizes de jure the de facto transfer. You hear that? The de jure, the de facto transfer of sovereignty caused in part by the original sovereign's extended negligence and or neglect of the area in question. Boy, y'all better listen to me. I'm probably the smartest man alive today. Okay? So, as a result of us not having a king and the people not selecting the king, you allow for the land to be transferred, the people to be converted into chattel property, and then used on that land for the purpose of commerce, do what we call conversion of a state, which is about what we call easement by prescription. What is easement by prescription? Let's define it. Easement. You hear this, y'all? An easement is a non-possessory right to use in or enter onto real property of another without possessing it. It is best typified in the right of way which one landowner, A, may enjoy over the land of another, B. An easement is property right in type of incorporable property and itself at common law in most jurisdictions. Okay? And all that is subject to the restatement third clause, the statement clause. Okay? Going back to the common law interpretation of how the conveyance of property should be done. Okay? And if it's not done right, then that means that the law of what we call necessity must be called for. Okay? And that law of necessity is the ability to break their law. Okay? And the justification for breaking their law, because their law is not your law. And the only law that you can use, which is your law, to prove that you are in fact and indeed a citizen of America, is the common law of England. Okay? The common law of England. Okay? So if you're an advocate and if you are lobbying for the juror rights, all right, if you are advocating and lobbying for the juror liberties, if you are advocating and lobbying for your right to be protected under the common law, then you must invoke the law of necessity. Okay? Because under the laws of necessity, it's justified. Okay? It's justified. And the only way you can justify it is to be a part of the law. And that is the common law of England. So with that, I'm going to digress on this lesson. I open the floor for questions. If there are any questions, please come forth now and please state them for the record. Any questions? Come on, somebody got questions. Greetings, Brother Cornier from the House of Cornier. Glad you was able to be here. Hope you caught the whole lesson. Greetings, Countess Walker. Greetings, C.A. Murphy. Greetings, Brother McGarrett from the House of McGarrett. Greetings, Brother Thompson from the House of Thomas. Greetings, Archbishop Belmont from the House of Belmont, as well as Brother Marquise from the House of Marquise. Glad all of you were able to enjoy this marvelous lesson, as well as I hope that you're able to comprehend this marvelous lesson, because if you were, then this will be a marvelous day. Okay? This will be a marvelous day for you. Okay? Because the only person that really can solve this border crisis is I, your king. All right? So with that, does pagan means slave? Pagan don't mean slave. Pagan means somebody who practices certain ways. And you can't be a pagan until somebody call you one. You can't be a pagan until somebody call you one. If somebody call you a pagan, that means that they must know that whatever you practice is false. Okay? And if that's the case, then that means anybody can be a pagan if they can't prove what it is that they practice is real in fact. And you need law to do that. Okay, so anybody cannot prove that they are or their culture or that their right to be here on this planet is in fact true, then they need to produce that by some type of law, okay, that exists throughout time, okay. The Berber's law existed throughout time, going back to the Stone Age, okay, before the Stone Age, and it was found in all areas: Nubia, Egypt, Iberian Peninsula, Britain, North America. All right, it was found in legislations, constitutions based upon the law, the common law of England. Okay, the common law of England. You're welcome, Brother McGarrett from the House of McGarrett. All right. So I hope that you all realize how important it is that the last 4 lectures that I've watched, that I've done, okay, the last 4 lectures that I've done, especially this one, okay, especially this one, will set the standard. Okay, my next court date for the civil complaint I filed is dated for this month, which will be the 22nd, which will be a Friday. The defendants have till this Friday to respond to my opposition based upon my necessity, necessity to break their law, which is justified by way of the law of necessity, which they claim was a criminal offense. All right, based upon my opposing arguments, there has been no reply yet, and I don't think they're going to be a reply, because if they don't reply, then the purposes for the motion in lieu of their motion to dismiss is waived, because for in the reply you are not to respond to the arguments raising your motion. The reply motion is based upon the arguments in lieu of the opposition to your motion. So the reply motion must oppose the opposing motion, and if you don't oppose the opposing motion, then your reply is waived for the sake of that motion. Okay, and if that's the case, that means that there's no genuine material facts to the opposition, or why your motion to dismiss should not be granted. Okay, which is based upon my opposition, which the court must take as genuine material facts, undisputed, based upon the public record, which allowed me to violate their law based upon the laws of necessity, which was justified by their law, going all the way back to our ancestors. Okay. So the next court date for the civil case will be, like I said, the next week, which is 22nd, and that will be based upon the motion hearing, which I oppose in lieu of the defendant's motion to dismiss, was based upon their claiming that I did not follow the statutory requirements as given by their laws and statutes that they provided, which, according to the common law, they're non-substantial. They don't have any weight at law in lieu of fraud, conversion, malice, ill intent. You have no immunity for that, all right? Because everything that the complaint was filed in the criminal complaint, which is going to be heard on December 9th, okay, as a result of a revamping of the courtrooms in lieu of the pro arraignment indictment criminal offense brought forth by the state of New Jersey. But I'm pretty sure if there's no opposition, there's no reply to this opposition to this criminal complaint, then they're really screwed in that criminal complaint. All right. Because at that hearing for the motion on the 22nd of this month for the civil complaint, they must reply to the opposition, which is to deny their motion to dismiss, because there's no dismissal when fraud or willful intent or malice has been done based upon the same statute where they claim their immunity from, which is Title 59 of New Jersey Revised Statutes. All right, does that answer your question, Brother Thomas from the House of Thomas? Well, I'll wait for Brother Thomas's response. Any more questions? No problem, Brother Thomas. Transparency is what we all need, okay? And the only way you can get transparency is by the law of necessity, okay? By law of necessity, that gives you ability to attest that acquisition of sovereignty. Okay. If you don't attest it, that means that you're not calling on the need of necessity. Okay. The need to violate their law. Okay. If it ain't my law, I'm gonna violate it. All right. Because if I don't violate it, then the law remains in effect. Okay. Why you think we got the background up here? We were enslaved and we continue to be in slavery because of the history that we don't know in regards to how we were enslaved by change. Okay. And the history that we don't know about how we were enslaved and changed is based upon the laws they put in those books to validate to slavery, which was called those black codes. Okay. Those black codes of Noir. All right. We went through that in my last lecture. If you understand that, you understand that the only way out of those black codes is to attest those black codes and breaking those black codes laws and going back to the law that existed before the black codes. And we know that that's the laws that were created for them, the laws of vagrancy, and imposing those laws back on them, all right, by way of attestation, all right? So once again, I thank you all for being obedient. I thank you all for taking a stance and standing alone for the preservation of just the law. Okay, and I promise you, okay, I promise you, once your king is restored, your estate will be restored. Okay, but you must take your oath to honor your king. Okay, and when you take your oath, that means to act as a member would do formally or informally. Okay, honor the common law of England. Okay, and with that, I'm going to greet you as I always greeted you, and that's in peace and love. Peace. No problem, Brother Thomas. No problem. All right. If there's any platforms out there that you know of, and you're not trying to expose them, the ancestors will know. Okay. Because a lot of you, I know that are viewers of other platforms, and I'm pretty sure if you're an advocate for this information, then you need to be dropping information on them. Because as I always say before I close out, it's better for you to not know me than to know me and not listen to me. It's better for you to not know this than to know this and not follow it. Okay? Because in the end, there will be judgment, justifiably. Okay? So with that, peace, Brother Cornier from the House of Cornier. We're glad you were able to join me, as well as everybody else who showed up for the cause. All right. We must invoke the law of necessity. All right. We must invoke the law of necessity. And the law of necessity is to break their color of law, which is a necessity for the English people here in America. And with that, I say peace